Good morning or afternoon or whenever you're watching this. Not legal advice of all days. Please like, subscribe, share, comment, show it to your animals. Hopefully, this stirs information, stirs your thoughts about information. Um, Not legal advice, obviously. Please don't like or subscribe. Certainly not financial advice, also. So, notwithstanding whatever I'm saying today, please use your own judgment and make decisions accordingly. So, I'm going to talk today about GTII and the issue of an acquisition. And I'm going to do it based upon information that's been provided to me by the company and its representatives. I have a format for doing these videos, and I'm going to stick to it. So before we get started, I have three quick jokes about CEOs, because kind of CEOs are at an issue. So how does a CEO write love letters? In a merger of words and emotions. The energy company's CEO credited her success to a series of power moves. And last but not least, I prefer this. I think this is the best of the three, my opinion. Did you know that McDonald's fired their CEO, Steve Eastbrook, and he just got a new job at Old McDonald's Farm? He is the new CIEIO. Okay, now let's go to the serious stuff. So, the reason why I'm disclosing this information is it was, I thought, material. It was provided to me publicly by representatives of GTII who affirmed this information. And as a result, I felt compelled to go forward. I gave representatives of GTII the specific opportunity to give me a reason why I shouldn't disclose this information. As of the time of making this video, that has not occurred, so I'm going forward. Before I go into detail, it has nothing to do with the Alpine scumbaggery. So um, it really has nothing to do with that part. That's the short interest, etc. Not dealing with that. This has to do with a potential acquisition by GTII. And I felt comfortable coming forward with the information because I gave GTII and its representatives numerous opportunities to disavow what I was going to say or to correct me. And again, as of today, that has not occurred. So, not saying this is the most crazy information, but I gave the opportunity to GTII and they've not corrected me. So I feel comfortable going forward with that. Now let's get into the story a little bit, because I had concerns about what GTI was doing. It's basically a shell company, so I had concerns about what they were trying to do to bolster the share value for stockholders, and the share value had plummeted, I think, over time. And it's a shell, so either it will, basically merge with other companies or generate a shell for other companies, and based on that, it'll generate revenue, etc. Or, as has been promised or discussed, there was the issue of Alpine and whether there was a short issue, and John Hurry and all those people. So some people believe that GTII would run because of that short stuff. And obviously, I'm well versed on the history of the proceedings against Alpine. I've done more videos than I would like about that, explaining that, including one yesterday. So that is up to date. So I'm aware of that. But I thought in the short term, because we don't know when that's going to happen. And we don't know if that's going to actually cause a short squeeze in the stock. I have no idea. I would like Alpine to be out of business just because of the way they do business. But we don't know. So the alternative to that is, if you have a shell, especially if you have a shell, the only way you're going to get any shareholder value is if the shell brings something in, becomes something. And over the past several months, I'd heard from various sources that they were working on an acquisition. And I concluded this is just my conclusion. I concluded that if they got an acquisition, that would positively impact the company and the stock price, and because I'm a shareholder, I would make more money. So I was happy about that. But over time, so that's over several months, but over time, I started hearing from various sources, some directly, and either they were potential business partners of GTII, or they were people that knew potential business partners of GTII, and I received complaints about the difficulty in trying to close a transaction with GTII, and there was no substantive reason for the denial, but it was just that it was difficult for, or at least this is what they communicated. Since I was not involved, I don't know, but what they communicated, it was difficult to consummate transactions with GTII. And there was more than one, apparently, that was under discussion. And again, I don't know the terms. I don't specifically know the parties. I don't know how many there were. I don't know how many there are currently, but that's what I heard. But it caused me concern for all those various reasons. So as a result, at some point in time, and that point in time was February 6th, I basically communicated with GTII's officers and directors, their in-house counsel, and I communicated who I was first, shareholder, and I communicated my frustration with what I heard was kind of their inability to get the job done and close a transaction, amongst other things. And so that was communicated February 6th, 2024. I didn't hear directly from any of the officers, directors, or any of management. But at some point in time, I heard from in-house counsel. He confirmed they had received my demand. Let's say it's a demand. It's basically a demand to get off the pot and complete the deals that you say that are ongoing, or that others have said were ongoing. So I try to light a fire on them. I indicated also that if they're not, if they're not going to do anything for the benefit of shareholders, amongst other reasons, that I would consider all remedies available to me as a shareholder, and obviously that I'm an attorney. So that was communicated. I had some further discussion after that with another shareholder attorney who apparently had communication with management, and communicated back to me and basically sought that I not pursue my legal remedies quite yet, and that I kind of wait and see what developed, because apparently things were in process. So I agreed to abide by that, and did. And I think in my originally in my February 6th demand, I gave them 20 days to the 26th to respond. I heard from this attorney investor who had communication with management at or about the 26th. I probably heard from him before that, I believe, but I heard at or about the 26th. He asked for patience. I gave some patience. At no point in time did I agree not to do anything, but I agreed to exercise patience to see what was going to go on, because it was my impression that, from what my discussions were, that things were in process and in progress. And that was not only from what I'd heard before, but from what I'd been hearing in my dealings starting on the 6th, my dealings with the representative I mentioned, the response from in-house counsel, etc. So February 26th comes along. I agree to give a little more time, but I have not agreed to waive any of my rights or what I'm going to do. Some time passes. I become uncomfortable because I haven't heard enough to feel comfort, and I basically ask, give me some public information. I think I asked specifically for public information, or information that could be public, that could support what you're doing. I don't hear anything, and I don't remember why, but at some point in time, I basically tell them that, unless I hear further, I'm going to move forward. And it probably is about March 3rd. I think it's about March 3rd. And on March 3rd, I get at some point in time, I reached out, by the way. So during these times, I'm reaching out to the officers and directors. So it's probably multiple times, and they know what's going on. And I reach out to in-house counsel, so he would communicate with the officers and directors too. And then at some point in time, I get a letter, and I think it's March 3rd, because that's what I'm looking at right now, and right in front of me. It's this particular document, and you notice it's Fattal, Fattal, the heading. Is I get a letter, and I get an email letter, email and an attachment from this gentleman, and basically saying, hold off, things are in process. I don't remember specific language, but because I'm going to address some other language. But he basically suggests that to exercise some patience. I say, okay, but I'm not agreeing not to move forward. I think I responded quite quickly. So if he sent me a letter, something on the 3rd, I probably responded on the 3rd. And I said, okay, I'll hold off pursuing any legal stuff for the short term, or at least, no, I won't hold off. I will consider holding off. He said, I don't remember if it was on the phone or later, and because I'll address it coming up. He said there's ongoing stuff and I can't disclose specifics, which I understood, but the 10K that would come out before or on March 31st, 2024, would disclose more details of what was going on in terms of the acquisition attempts by Gtii. So I heard that, and that gave me some information. I followed up because I wanted more. I wanted more confirmation of that information. I wanted to be sure. I wanted to be sure who this attorney was. I wanted to be sure that the officers and directors knew all this was going on. So after a couple, I think I tried him 3 more times after the 3rd to get some additional information. I think I also sent a request to confirm whether he was representing the individual officers and directors and management. And I said if I didn't get a response by 5 p.m. on March 8th about his representing the officers and directors, that I would assume he's not. And I had gotten no indication to the contrary. And I also, because I tried now since March 3rd, at least 3 times, maybe 4 times to get a hold of him without a response, I said, if you don't respond, are you still representing GTII? So didn't get a response. 5 o'clock comes, March 8th, which is yesterday. And as it turned out, the letter that was dated March 3rd was received on March 8th. And here is the, if I can get it, the overnight mailing I got, and plus the postal thing. And that included this letter. It's dated March 3rd. So I got it on the 8th. But I hadn't heard from the guy, and nothing from since the 3rd. So I reach out to the officers and directors again, because I got no indication he was representing them. So I contact them directly. I basically lay out, and I'm looking at the email I sent. So here's the email, and I've yellowed out, just for my purposes, the points. And as I indicated to you, I gave them till 5 p.m. Pacific time to respond on the 8th. And my email, as it turns out, is 5:02 p.m. I sent it only to the officers and directors. I did not send it to the attorney because he wasn't representing the officers and directors. And he hadn't reconfirmed that he was representing GTII. So I didn't send it to him. I sent it to the officers and directors. I basically repeated, tell me why I shouldn't tell what you've represented in the letter about an ongoing transaction. Tell me why I shouldn't disclose that publicly, and give me a reason by 9 p.m. today, Sunday, the 10th of March. And I gave him until 9 p.m. Pacific time. I said, give me a cogent and persuasive reason why. That was my request. And as I sit here today, and it's 11:45 a.m. Pacific time, I have not heard anything, period. And in this email that I directed only to the officers and directors, I also indicate what was represented in the letter. about the ongoing acquisition efforts, etc., and what had been said. And I also indicate that, I have to presume that what I was told is true, because obviously, if it wasn't true, and I'm not a criminal lawyer, but I would assume if somebody makes misrepresentations about securities to shareholders, that might constitute securities fraud. Not that I know, but that would be my concern. So, in essence, I send out this email to the officers and directors. I indicate this is what's been told to me. Give me a cogent reason why not. I shouldn't go public about what was told about the acquisition. And if just so we're clear, if this thing's false, then you got a lot of problems. I, though, felt comfortable because it had been repeated multiple times during that month now, in some regards. And then specifically, when I get the letter on the 8th, so I have it in hand, I look at it and I feel comfortable based on the language. So it's not just what's in the letter itself, it's I've been told things over this month, and it's kind of gradually building, so I have a level of confidence. And the specific end was when I get the letter on the 8th, I send this email on the 8th to the officers and directors. I give them, some time to respond and counter or do whatever they want to do, but I don't send it to the attorney. And I had reason besides what I indicated. There was another logical reason I did it that way, and so even though I don't send it to the attorney, at 6:35 p.m. Pacific time, I get an email back from this lawyer who I didn't send the 5:02 p.m. email, and he basically says that he's been very responsive. And again, I'm not going to argue about that, even though he didn't respond to 3 or 4 of my inquiries. He reconfirms that he represents GTII. He doesn't say anything about the officers and directors, so I presume he's not representing the officers and directors. And he indicates that he's continuing to be employed by GTII, that he was hired on January 16th, 2024, and that my beliefs about, and I'm kind of characterizing this a little bit because it's very skimpy language, but he led me to believe that my impression that GTI had not actively worked to close a transaction before was misguided, and they had been really worked hard. Now, there's no reference in there to me not disclosing what he had put in the letter that was not marked confidential, was given in a public way, and that was here on the 8th. He reaffirmed his position for GTII on the 8th, and I know the officers and directors of GTII knew about my letter and my work with him, because that's how he found out to respond to me at 6:32 p.m. on Friday, March 8th, without me sending him the 5:02 p.m. email. So I felt comfortable that everybody knew what everybody else was receiving. I felt comfortable that everybody knew the language that I referenced in the email, confirming the ongoing efforts at closing a transaction and the ramifications if not true. So in the 6:35 p.m. email he sent me, he said he tried to call me. So what I do is I send him an email about, because I find out about this maybe like 7 p.m. Pacific time. So now it's 10 p.m. Eastern time. I figure he's probably not available at that hour, but I don't know. But what I do is I send him an email. I say, why don't you give me a call tomorrow at 8:45 Pacific time? And, if you have anything you want to address, feel free. So that email goes out 8:45 a.m. the next day, Saturday. I get no response, but I reach out to him. So I call him. No answer. I leave a message. I follow up with an email. The email to him, I say, I'm following up. I called yesterday. Please leave me 2 times on Sunday. If you want to speak, just leave me a couple times and I'll arrange to speak with you. I have not heard back from this gentleman as of now. It's 11:50 a.m. Pacific time on Sunday. So as a result, I presume he has nothing to add other than what I've indicated. So now let me get to the letter that he sent me, and it's short and sweet. It supplements what I was told. I just thought it was interesting because it's public, and it I think it puts if it's not true, I think it creates a lot of problems for the board and the executives. So I presume, therefore, it's true. And if it's true, I think it's good for GTII. Just my opinion, but let me kind of address what it says. So it's dated March 3rd, 2024. It's sent to me. It says it's so this is kind of funny to me. It's dated March 3rd, 2024. It's a response. It says it's a response to my letter dated February 6th, 2024. So it took about 4 weeks to respond. Might be slightly long. And he says, who he is, who he represents, that he can't openly provide private information, which I'm perfectly fine with. He kind of indicates that. Then he responds to my claim that they really haven't done enough to close the deals. He kind of suggests to the contrary, and then we get to the part that I think is really important. This is only 4 paragraphs long, less than a page letter, maybe 2/3 of a page. So, starting with the third paragraph down, it says, understandably, it is in the best interest of all shareholders that GTII complete a fruitful transaction. Furthermore, GTII is working towards closing its outstanding acquisition target as soon as possible. As you can understand, the acquisition target is a separate legal entity not yet controlled by GTII. We ask that you await GTII's upcoming 10-K annual report for important details that will be made available to our shareholders. Thank you for your patience. So I saw that information. I gave them the opportunity to modify, contest, alter, in any way, say something to the contrary. I feel that they've affirmed that decision. And I know management knows because I've communicated with them. So everybody's on the same page. They've indicated that they have an ongoing acquisition target in progress they're working to close. So that's what I believe. I believe if it's false, that these people have a problem. And so the way I look at it, one of two ways. Could they not be truthful? It's possible. That'd be quite a risk. And they've affirmed it multiple times in my discussions about who's representing who, etc. So I feel comfortable that they know. So I feel reasonable comfortable one of two things: that a deal is forthcoming, going to close, or that the current board and executives will be gone. And if the deal closes, in my mind, it's great for GTII. And if what's represented by these people is false and the board and management are gone, as would be necessitated by that, then I think whoever became the new board would consummate the transactions to the people who of all those deals that, and I don't know which one, but all those deals that were pissed off about the way that, or the way that they weren't able to consummate a transaction. All those I'm sure would work with management. I don't know that firsthand, of course. That's just my opinion. So again, the reason why I disclosed it was because I felt it was confirmed. I felt it was, I don't know if it's insider information. I really don't know. And I certainly haven't acted on it. I have shares of GTII. I haven't done anything. Since I've been involved in these discussions, I've just been sitting, trying to see if I could create, I could be positive and create a resolution. So that's where we are today. The way I see it is they've confirmed they're in process of closing a transaction that would benefit GTII. If that's not true, I think they have a big problem. It's in a public communication, not confidential, not private. Everybody's on notice. So I feel pretty good about it. And that's why I came forward. I didn't want to withhold the information. I thought it might be important to other people. I don't know how they should use it. They should use it on their own, but that brings you up to speed literally 11:55 a.m. Pacific time on Sunday. And this video, I think, will be out Monday morning. And that's it. Hope everybody's well. Hope that information is helpful. And we'll talk later.